Thank you for attending today's Researcher Talk. I'm Richard McCulley, the historian at the Center for Legislative Archives, which sponsors this series. We have never tried to lure historians to come speak to us during the not always pleasant month of August, and we continue that very sensible tradition next month by not having a Researcher Talk. But the series resumes on September the 15th, when we'll host William McAllister and Joshua Botts, two historians at the Office of the Historian at the Department of State. They will discuss their book on the history of the foreign relations of the United States series, which earlier this year was awarded the George Pendleton Prize for an outstanding book on the history of the federal government. They will discuss how Congress helped originate that program and has played a very important role in that series' evolution over the past 150 years. We are very pleased to host today's speaker, Kate Masur, Associate Professor of History at Northwestern University. She has researched records at the center several times. Welcome back, Kate. She will discuss Black sailors and citizenship in the era of the gag rule, part of her book project tentatively titled Police Powers, the Anti-Slavery Movement, and the Origins of the 14th Amendment. Professor Masur is the author of An Example for All of the Land, Emancipation and the Struggle Over Equality in Washington, D.C., published by the University of North Carolina Press in 2010. In addition to prize-winning journal articles, she has published widely in such venues as the New York Times and has worked with the National Park Service on projects related to the 150th anniversary of Reconstruction. Her work has been supported by the ACLS Reskemp Fellowship, the National Endowment for the Humanities, and the Kluge Center at the Library of Congress. I could go on, but as many of you are aware, Professor Masur is quite an accomplished scholar, and we are very pleased to have her today. We should have time for questions after the presentation. Please remember to raise your hand before you ask a question so we can pass the microphone. Thank you very much for joining us today, Kate.
Well, thank you for inviting me. Thanks for having me here. It's really great to be here at the National Archives and have a chance to present new work that I'm doing. And I want to thank Richard McCulley most of all for reaching out to me and inviting me to give a talk here today, and also to congratulate you on your upcoming retirement. And that sounds like a good transition. I am going to be talking about a new project that is underway that I'm currently working on today, and I'm going to highlight research I've done here at the Legislative Archives. I don't have a lot of slides, but I did want to use the opportunity to have slides to show you a couple of the petitions that I have looked at here at the Legislative Archive. Although I found when I was putting the slideshow together that petitions don't lend themselves very well to slideshows. I hadn't really thought of that before because they tend to be really vertical and the slideshow is really horizontal. So you'll see how I tried to solve that problem, probably somewhat awkwardly. All right. So in late November 1833, back in the past, we're going back in time, a veteran ship's steward named Joseph Thompson came into the office of a Boston abolitionist who was also a lawyer and a justice of the peace. And he gave a sworn affidavit about his experiences as a free black sailor in New Orleans. A voyage 4 years earlier had taken Thompson first to Bordeaux, France, and then to New Orleans. When he arrived in the Crescent City, the 30-year-old Thompson had requested from the ship's mate a portion of the pay that was due to him. The ship's mate became angry with him, charged him with stealing, tossed him in jail, and then attempted to sell him into slavery. I refused to go, Thompson attested. Fortunately, he had connections in New Orleans. He spoke some French and was able to ask the jailer to send word of his imprisonment to two white acquaintances, a landlord and a merchant, the latter of whom he had sailed with long ago. The two white men came to jail and secured Thompson's freedom. Painfully aware that things could have turned out very differently, Thompson concluded, quote, "If I had not had friends in New Orleans, or if I had had them but could not have sent a message in French by the guard, I should not have been able to recover my liberty and should, in all probability, have been in slavery at this time. Thompson knew whereof he spoke. While in jail, he had encountered 9 other free black men incarcerated and vulnerable to sale into slavery. There was a free man he had known in Baltimore, William Johnson, now shackled and whipped. There were 3 fellow ship stewards whom he had known along the way, 2 more men from Boston, 3 from New York, and 1 from Portland, Maine. All were slated to be sold as slaves after 20 days in jail. Unable to benefit from connections like the ones Thompson had, they were without recourse. Thompson asked one of his friends to help, but that man's efforts were unavailing. Thompson himself went to the ship on which one of the stewards had arrived, which was anchored along the levee, and implored that ship's mate to send his free papers, or at least to visit the steward in jail. The man refused, chasing Thompson away and shouting racial epithets at him. Quote, a continual stream of free-colored men from Boston, New York, Philadelphia, and other seaports of the United States, Thompson said, is passing through this calaboose into slavery in the country. In my talk today, I'll explore how Northerners in the 1830s and the early 1840s galvanized against the problems Thompson described, the arrest, incarceration, and potential sale of free black men in Southern ports. Although self-described abolitionists were part of this effort, many of its primary movers sought to distance themselves from the radical abolitionist movement and to make a different point. They were not arguing for the immediate abolition of slavery, but rather for fair treatment for free people of African descent, for fair treatment for people of African descent who were already free. They targeted 2 types of Southern state laws. First, laws that permitted the arrest and incarceration of any person of African descent found without adequate proof of freedom. And second, laws that were directly targeted at black sailors, that treated black sailors as potential criminals and restricted their liberty while their ships were in port. The heart of the Northern movement against racially discriminatory laws in the South was the maritime state of Massachusetts. Their activists argued that the state must protect its own black citizens when they traveled in other states. Their use of the term citizen in this context, I'll explain, was very significant. After several years of pressure in 1839, the Massachusetts state legislature explicitly condemned the Southern statutes. But the state government and its supporters were powerless in the face of resistant Southerners who claimed that their racially discriminatory laws were necessary to secure public peace and safety. Eventually, and as a result of pressure from Massachusetts, anti-slavery legislators in the US House of Representatives took up this issue. And I'm going to spend some time today highlighting some remarkable petitions on this issue that I found in the legislative archives. These are petitions of sailors and ship captains who were part of the movement to insist that the South's racially discriminatory laws were unconstitutional. They advanced their agenda in the era of the gag rule, when both houses of Congress refused to entertain petitions that called for the abolition of slavery. But these protesters insisted that they were raising a different issue. They were talking about the basic rights of free people of color. And in 1842 and 43, they finally managed to get a hearing in the House of Representatives. I see the debate over the rights of free black Northerners traveling and working as sailors in the South as an important episode in the history of American constitutionalism. Through the activism of sailors, captains, and their allies, many Northerners came to understand a significant shortcoming in the American constitutional order. That is that under the existing framework, it was impossible to ensure that all free Americans could enjoy basic personal liberty, the ability to move from place to place within the nation unimpeded. It would take an amendment to the Constitution itself, they realized, to even promise such protection, much less deliver on it. In this sense, the antebellum struggle to protect Northern black sailors who docked in the slaveholding states was a crucial prelude to the 14th Amendment. So that's the larger picture of what I'm trying to do here. Okay, so some background. We need to understand the racist laws passed by Southern states and by some Northern ones in the context of a long history of laws designed to secure public peace and order. These laws often alluded to what were then called police powers. That is, the power of governments to do what was necessary to structure a peaceful society and ensure their own continued existence. In the United States, police laws came out of the English common law tradition, just as the better-known tradition of individual rights did. Most relevant for our purposes are English poor laws. Starting in the 16th century, poor laws of England attempted to address poverty and dependency by establishing rules by which people must establish residency in their own particular jurisdictions. Poor people and other groups that communities considered undesirable, including prostitutes, beggars, gamblers, and gypsies, had to carry passes from one jurisdiction to another and obtain permits to reside in certain places. And these laws, of course, made it difficult for these kind of marginalized groups of people to settle in new communities. Colonists in British North America adopted variations on English settlement laws, which were founded on the police powers of local government, that is, the power to promote order and public peace. In the colonial and early national periods in the United States, local jurisdictions used such laws to regulate both internal migration, that is, movement from one county or state to another within the nation, and immigration from abroad. So the poor law tradition was actually the foundation of both certain kinds of settlement laws within the United States and also immigration law before immigration law was completely federalized. It was these sorts of settlement laws and the larger principle that communities could exclude or regulate groups of people based on the perception that they posed a threat to community well-being that provided the foundation for the racially discriminatory laws in the United States. Concerns about the in-migration of free Black people usually fell along two different lines. In slaveholding areas, policymakers feared that free Black people would foment uprisings among slaves. In both free and slaveholding jurisdictions, they feared that free Black people would be poor and therefore a drain on public resources. In the jurisdictions that passed laws restricting the entry and settlement of free Black people, courts typically upheld those laws as appropriate uses of police powers. For instance, a prominent Federalist judge named William Crant, who was actually originally from Massachusetts, gave voice to this logic in an 1821 holding that the District of Columbia's statutes restricting the mobility and residency of free Black people were entirely unconstitutional. They were entirely constitutional. Local governments, Crant affirmed, had, quote, the right to pass laws to preserve the peace and morals of society. If there be a class of people more likely than others to disturb the public peace or corrupt the public morals, and if that class can be clearly designated, then governments could impose on members of that group reasonable terms and conditions of residence designed to guard the state from the evils which it has reason to apprehend. So these racially discriminatory laws were upheld as appropriate uses of police powers. Now, the federated structure of the United States allowed different states, as well as the District of Columbia, to have different laws when it came to free people of African descent and any other matters of police powers. But what happened when people traveled from one jurisdiction to another? This issue came up in a very pointed way with respect to the question of whether slave owners could bring slaves into states where slavery had been outlawed. Was the government of a free state obliged to uphold the owner's title to a slave, even if slavery was not sanctioned by state law? Okay, imagine a slave owner trying to bring a slave into Massachusetts or Pennsylvania. That slave, let's say, for example, runs away. Is the state obligated to bring the person back and observe the laws of slavery, even if slavery is not allowed in that state? This question has been explored in some depth by the historian Paul Finkelman, who showed that in the early 19th century, northern states did honor the rights of traveling slave owners, even when their slaves escaped. And that gesture was called comity, not comedy, but comity. That's the idea that local government should sometimes allow sojourners, people passing through the state, to enjoy rights or privileges that they enjoyed at home, even if they were not legal in the place where the person was traveling. It's an old concept in international law. Finkelman showed that comity gradually broke down as northern states increasingly rejected slavery, and as sectional tensions heightened, free states increasingly declared that slave owners had no rights to their slaves when they traveled to free soil. So the principle that actually once they come to free soil, they no longer have a claim to own that person. That principle evolved over time in the course of the antebellum period. But what happened when, in the kind of reverse situation, when free Black Northerners traveled to southern states, where state laws demanded that those people carry passes and be subjected to a variety of other discriminatory rules that made them vulnerable to arrest and even sale into slavery? Slave owners regularly claimed their citizenship rights allowed them to maintain control over their slaves even when traveling in states where slavery was illegal. Could free black Northerners claim that their citizenship in their northern states gave them the right to keep the rights they enjoyed at home, even in the jurisdictions in which they traveled, even if the jurisdictions in which they traveled did not recognize those rights, okay? So the other direction. Now, you might be wondering, why would any free black Northerner even want to go into a southern state? Mostly they wouldn't. Already facing difficult conditions in their own states, why would they want to travel into a region where they were tremendously vulnerable, where they risked arrest as runaways, kidnapping, and even sail into slavery? But many free black Northerners were sailors, and their work in the very significant coastal and international trade of this era frequently required them to dock in southern ports. A historian named Jeffrey Bolster has shown that in the first few decades of the 19th century, seafaring ranked among the 3 or 4 most common occupations among northern black men. Working at sea could provide men of African descent a better livelihood and relatively fairer pay than most landlocked work. Because free black sailors regularly traveled into southern states in the course of their jobs, and because they were closely connected to powerful commercial interests, it was in relation to them that significant issues of citizenship rights and federalism were discussed and hashed out in the decades before the Civil War. So they create, in their travels, in their employment, they create questions, or they raise questions that people have to grapple with. At first, the controversy over the rights of free black sailors in southern ports coalesced around the state of South Carolina and its distinctive Negro Seaman Act, passed at the end of 1822 by a state legislature reeling from the discovery of Denmark Vesey's plot to provoke a slave uprising. The South Carolina law required all free sailors of African descent to stay in jail while their ships were in port. This applied to both out-of-state and foreign sailors. So not just American people from the north, but from any other country. Protests began immediately and came from Northerners as well as from British, in particular British captains and diplomats. Opponents of the law argued that it violated the United States Constitution because it interfered with commerce, which was definitively in the domain of Congress. They also insisted that it was an unconstitutional infringement on the individual liberty of free men. Why should perfectly innocent sailors traveling for their jobs be deprived of their liberty while in port? Despite those initial challenges, the law was allowed to stand. And in 1830, in response to continuing protests by the British, President Andrew Jackson's Attorney General John Berrien of Georgia affirmed that the law was in, quote, perfect harmony with the United States Constitution. He argued that the law was a simple matter of internal police, resting on the principle that governments had almost unlimited power to make laws they deemed necessary to ensure their own continued survival, including regulating the liberty of groups they perceived as dangerous. Moreover, Berrien, the Attorney General, argued that the law did not interfere with Congress's power over commerce or with treaties it had made with Great Britain. He was writing in 1830 in a moment of extensive debate over the relationship between state police powers and the power of Congress and the federal government. So actually, he's writing in the middle of a lot of ferment about this issue, although mostly in relation to immigration and laws restricting the kind of state laws that restricted immigrants from coming in. But Berrien argued that Congress could override state statutes like the Negro Seaman Act of South Carolina only if the federal regulations in question that Congress wanted to make were necessary and proper to the preservation of the commerce of the Union. So allowing free blacks into the nation's ports was merely a matter of convenience, he argued, but not necessary. And therefore, state laws that excluded or regulated free black people were, quote, a justifiable exercise of the reserved powers of the states. So this is the language speaking directly to the Constitution. So in other words, the defense of these laws always ultimately rested on police powers. As a Wilmington, North Carolina newspaper would put it in 1836, such laws are, quote, essential to our self-preservation. They always come back to, we have to have these laws to preserve order in our society. It was in the 1830s that activists and policymakers in Massachusetts began in earnest to agitate against the South Carolina Negro Seaman Act and other racially discriminatory laws of the southern states. Their position was that although governments at every level were entitled to make laws to maintain peace and security. They could not make laws that treated people as criminals only because of the color of their skin. What a concept, right? Two Massachusetts state legislators, writing in 1836, dismissed any potential argument that black citizens of Massachusetts might be less entitled to protection than whites. If it be said the laws complained of, that is, these Southern laws, bear most hardly upon a portion of our population who are denominated Negroes, be it so. Does this alter the case? Are they not citizens? Have they not the same right which is enjoyed by all others, that of being protected by the government under which they live? Under the Southern states' police laws, these two legislators from Massachusetts argued men were deprived of their liberty, quote, on no other evidence than that of color and complexion. Now, it's significant that they identified color and complexion as inappropriate criteria for singling people out. It's intuitive to us now, but it was not then intuitive, as I hope I made clear. These legislators weren't arguing against policing laws in general. They were not saying that states didn't have a right to regulate populations they considered dangerous. They were merely saying that a person's skin color should not make him or her a suspect. Pressure continued in Massachusetts as anti-slavery news and elsewhere, as anti-slavery newspapers circulated accounts of free black sailors imprisoned under various racially discriminatory Southern laws. And in fact, the testimony I read earlier from Thompson was brought to light as part of an effort to alert people to what was happening to sailors in the South. The Massachusetts legislature took action for the first time in 1839 when it passed resolutions condemning the statutes as both unconstitutional and, quote, in utter derogation of that great principle of the common law which presumes every person to be innocent until proved guilty. The Massachusetts resolutions of 1839 empowered the governor to use public funds to send emissaries into Southern states to get people out of jail. But in the larger sense, what could really be done? States could not tell other states what laws to pass. Besides relying on Southern legislatures to change their mind, which they were not going to do, the only other recourse was to the federal government. Yet the federal role here was not immediately clear. In 1830, of course, the Attorney General had declared the laws completely constitutional, insisting that they didn't conflict with Congress's jurisdiction and that they fell into the category of powers reserved by the states. So was it possible to challenge that interpretation of the Constitution? In a significant 1836 petition in Massachusetts, petitioners had turned to the Constitution's preamble, but that was not necessarily the best place to go. The preamble said that the purpose of the Constitution was to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. So the preamble invoked justice and liberty, which was good for those who opposed racist Southern laws, but it also alluded to police powers, the power of government to ensure tranquility, to provide for defense, and to promote public welfare. So although this part of the Constitution could be used to argue for liberty and equality, it could also rather easily be turned to the other direction as a statement that security came first. Better than the preamble was the Constitution's language about citizenship and comity. Now recall, this is before the 14th Amendment created the idea of birthright citizenship and the idea that everyone born in the United States was a citizen entitled to equal privileges and immunities of citizenship. That was passed by Congress in 1866 and ratified in 1868, so we don't have that yet. In most situations, state citizenship was more important than national citizenship in this period. National citizenship would come into play if people were traveling abroad. They would carry a US passport. The United States government considered itself sort of responsible for US citizens when they were out of the country. US citizenship came into play when immigrants were coming into the United States. But for matters internal to the United States, citizenship was considered a state-based status. And that's how the Constitution referred to it in Article 4, Section 2, which read, the citizens of each state shall be entitled, so each state shall be entitled to all privileges and immunities of citizens in the several states. This clause referred only to state citizenship, but it also suggested a federal role in ensuring that state citizens enjoyed privileges and immunities when they traveled to other states. So it was the one place in the Constitution that these people from Massachusetts and their allies could kind of grab onto to try to make the argument to Congress or to the federal government that they needed to step in against these racially discriminatory state laws. Now, Southern leaders usually deny that this clause of the Constitution, this Privileges and Immunities Clause, was even relevant to the question of free black sojourners in their states. They did not recognize their own free black residents as citizens, nor did they believe that free blacks whose home states considered them citizens should be treated as citizens when they visited Southern states. By contrast, Massachusetts and other Northeastern states insisted that free people of African descent absolutely were state citizens, and in doing so, they construed them as fully vested members of the community. They rejected the idea that people of African descent could be singled out based only on their skin color for special regulation, even in the name of policing and public order. They insisted that the state government had an obligation to protect those citizens when they were mistreated, while in other states, similar to the way a national government was obliged to look after its citizens when they traveled in foreign countries. And they argued that the US government had a role to play in protecting all citizens, including black citizens' basic rights when they traveled within the nation. Okay, this argument that they're making is not at all accepted by courts, by any major interpreter of the Constitution. They're basically advancing an argument that they wish people bought into, but it's not actually what most people subscribe to. But it did provide an opening for going to Congress. Not surprisingly, if you're aware of the history of Congress in this period, a key figure in the congressional side of the story was John Quincy Adams, the former president who had lost his bid for re-election in 1828 but was elected to the United States House in 1830. Well known for his campaign against the gag rule, in January of 1842, Adams was working with other anti-slavery Whigs to bring growing numbers of Northerners around to their view that the slave power in Congress had grown much too powerful. That January, Adams provoked an uproar in the House by introducing a petition that called for the dissolution of the Union, a petition from Massachusetts. And then in the course of defending himself against censure for having introduced that petition, he raised the issue of the unfair treatment of black sailors. On February 2nd of 1842, Adams persuaded the House to pass a resolution asking the president to submit to the House all documentation from the State Department regarding earlier protests against the laws, and especially in 1823, holding by a federal judge in South Carolina that the original South Carolina Negro Seaman Law was unconstitutional. Now, most of these documents were the documents that were in the State Department were there because of the ongoing British protests against the laws. So the laws had created an international conflict, even as they also created these conflicts within the nation. Adams knew very well that those documents existed because he had been the Secretary of State during the Monroe administration when South Carolina first passed its controversial law. So he, in fact, was one of the main people involved in kind of passing these documents back and forth between South Carolina and the British government. Now we get to see some petitions. So after Adams gets the House to resolve to investigate the unfair laws of South Carolina and produce these papers, people who cared about this issue in the Northeast, and I'll say in Cincinnati, galvanized and sent petitions to Congress. These are mostly from sailors and captains and their allies, ship captains and their allies. So this is a petition from self-identified black sailors in New York. It's a petition of 220 people who identified themselves as, quote, free colored citizens of the United States and the state of New York. So they're using that citizenship language, who claimed that by virtue, and this is the text of the petition, who claimed that by virtue of their citizenship, the Constitution guaranteed them, quote, rights of life, liberty, and the pursuit of happiness. In the course of pursuing their vocation in South Carolina, Georgia, and Cuba, they said, many had been, quote, arrested and thrust into lonesome prisons and dungeons, and all were liable to be thus incarcerated whenever our business call us to any of those named places in the due prosecution of our lawful concerns without any crime being brought or alleged against us except that of our complexion. They asked Congress to protect them in their, quote, lawful business and constitutional rights and privileges as citizens of the United States. And this petition is really long, so here's my solution. Picture it being long, but it goes on and on and on and on and on. No, that's the endorsement. This, on the side, the writing on the side said, these names were taken at a public meeting called by colored seamen. So I haven't found a newspaper account yet of that meeting, but clearly people met together to get signatures on this petition. Again, it has 220 names on it. African American sailors and their supporters in Boston sent a petition bearing 60 names asking Congress to pass laws that would protect them from the unjust and unconstitutional statutes of the southern states. Among the signers of that petition were notables William Cooper Nell, Charles Lennox Raymond, and Frederick Douglass. Ship captains also mobilized. From New York came a petition complaining that in Cuba and in the coastal United States cities of Charleston, Savannah, Mobile, and New Orleans, they were, quote, these are the captains, they were, quote, exposed to having their crews taken out of their vessels and incarcerated in prisons greatly to their prejudice and detriment of their interests. Nantucket captains likewise complained of the many perplexities and burdensome expenses associated with the laws that not only forced them to pay to get their sailors released from jail, but also required them to hire other people to do the work while in port that the jailed seamen would otherwise have done. The Nantucket captains added that these laws were far worse for the black sailors themselves, who were subjected to, quote, the loathsome jails of southern ports, or else were forced to stay home at the cost of abandoning their best means of an honest subsistence. Interestingly, from Cincinnati, so here's another way of dealing with the issue. I just made it really small. From Cincinnati came a petition from merchants and steamboat owners who did business in that city or were, quote, otherwise interested in the trade of the western waters, complaining of the great inconvenience and injury in the prosecution of their business resulting from laws in Louisiana and Mississippi that prohibited the entrance of free persons of color, and if they did come, subjected them to, quote, impressment and other penalties by which laws your memorialists are prevented from employing such persons as cooks, stewards, firemen, and otherwise on boats traveling between Cincinnati and those states. The petitioners believed as well that the laws were, quote, unjust to the colored persons themselves and are advised also that they are incompatible with the Constitution of the United States, and they respectfully pray that Congress will take such action on the subject as will address the wrongs complained of. So you'll notice that in suggesting that the laws restricting the liberties of black sailors impinged on the operation of trade and of sailors' ability to pursue their vocations, many of these petitioners were alluding to the Constitution, which gave Congress alone the power to regulate interstate commerce. So they're not just saying that it's a violation of individual liberty, but that it's also an encroachment on what Congress was supposed to have power over. In this way, they seem to be suggesting the direction they wanted Congress to go, or the ways that they believed Congress had the power to intervene in the situation. So these petitions are submitted in winter of 1842 after Adams's resolution passes. Now, what happened next in the House is a perfect example of how people who wanted Congress to deal with slavery and race worked to circumvent the gag rule in order to get a hearing. Okay, and this happened a lot. A lot of these kind of anti-slavery Whigs at this time tried to figure out ways of presenting petitions that dealt with slavery and issues of race, but didn't sort of directly call for the abolition of slavery so that the petitions would have to be heard. So President Tyler duly responded to the House's request for information about the history of the South Carolina law and protests against it. Meanwhile, agitation continued in Massachusetts as the state legislature passed more resolutions against the Southern laws, called for an effort to test the laws in federal court, and pressed their congressional delegation to do more. Jonathan Ingersoll Bowditch, a renowned merchant and captain, now organized a petition to Congress and garnered signatures from 150 of what John Quincy Adams called the most respectable and distinguished citizens of Boston. And some of them, they said, were owners and masters of vessels. So they sort of tried to find the most elite, respectable, shipping-oriented Boston people who were willing to sign on to this petition. This petition was brief and to the point, and it adopted the language of citizenship and constitutionalism that politicians and activists had been honing over several years. On ships landing in Charleston, Savannah, Mobile, and New Orleans, these highly respectable elite petitioners said, free persons of color employed on their ships were frequently taken from the vessels, thrown into prison, and then detained at their own expense. The practice hurt the interests of the sailors themselves, and it hurt the commerce of the states as well. They asked Congress to grant these sailors relief and render effectual in their behalf the privileges of citizenship secured by the Constitution of the United States. So again, they are trying to use ideas about commerce and citizenship to persuade Congress that there's a role they can play here. This is an advanced and very creative vision of citizenship in this period because there is no prevailing interpretation that citizenship needs to be protected at a federal level in this way. Bowditch, the person who kind of engineered this petition, found a congressional sponsor in Representative Robert C. Winthrop, who accepted the challenge of bringing the petition before the House and consulted with Adams about how to avoid having it tabled under the gag rule. In a letter to Bowditch, Robert Winthrop explained his strategy in introducing the petition and laid out very effectively the constitutional dilemmas they faced. And I think this is a really marvelous sort of statement of the problem. So I want to read it, but you can read along with this extended quote. So this is Winthrop writing to Bowditch in Boston. The mode of doing it, presenting the petition, under the existing rule is, however, very private. All petitions which do not come under the 21st rule, which is the gag rule, as this certainly does not, are to be filed with the clerk, and by him to be handled to the committee, which may be endorsed upon them, committees. I might make a special business of asking leave to present this in a more formal way, but the consequence would be that it would be laid on the table as soon as it was received and would never receive any consideration either by a committee or by the House. On the other hand, by offering it through the medium of the clerk, it is certain to go into the hands of a committee, and they must report on it to the House. On consultation with Mr. Adams and others of our delegation, therefore, I have determined to take this course. I have not quite made up my mind whether it is best to endorse it for the Judiciary Committee or for the Committee on Commerce. In either of them, I think it will receive proper attention, though doubtless there will be the customary flare-up whenever a report is made. The report can, of course, propose no very definite action. Congress cannot reach the state laws. The courts are alone competent to act on the subject, and even they would find it hard to get at them. The most that can be done by a committee is to recognize the seizure of free-colored sailors as a violation of their privileges as citizens, and the laws under which the seizure takes place as a violation of the Constitution of the United States. So what he's saying here is, in fact, precisely what ends up happening. Winthrop decides to go with the Commerce Committee, of which he happened to be a member. And the tabled petitions from the previous winter were then sort of filed with the papers of the Commerce Committee, which is an interesting little fact for those of us who work in archives. So the Commerce Committee was sent to report on this petition, and they soon reported back. The majority report, authored by Winthrop, strongly condemned the state statutes that restricted the liberty of free black sailors. It appended the historical documents that John Quincy Adams had requested, which included a powerful 1823 decision by a South Carolina federal judge that the original Negro Seaman Act was in fact unconstitutional. And the committee echoed that finding, concluding that it was unconstitutional, the laws were unconstitutional on 3 separate grounds. They interfered with the treaty-making powers of Congress when it came to sailors from other countries, especially England in particular, interfered with the commerce powers of Congress, and were a violation of individual rights. The committee conceded that the states did have significant powers to make their own police regulations, but it denied that the Negro Seaman Acts were legitimate exercises of that power. It was monstrous, Winthrop's report insisted, that people who were charged with no crime could be seized and incarcerated and permitted no legal process to determine their guilt or innocence, and that they could even be whipped and sold into slavery. To be sure, it was crucial to balance the need to maintain peace with the fundamental liberties of individuals, but how was this balance to be achieved? The committee did not seek to lay down a single principle, but simply claimed that the police powers could never be permitted to violate the constitutional privileges of citizens because of distinctions which originate in their birth and which are as permanent as their being. In this case, that is because of the color of their skin. Yet the report held that Congress could do very little, that the nation's legislature, quote, seemed to have no means of affording such relief or of effecting such a repeal. As Winthrop had stated in his private letter to Bowditch, the Constitution didn't give Congress power to pass laws that would override laws such as these. In the current constitutional order, the only possible avenue for undermining them was to turn to the federal courts. Many contemporaries realized that that route would be very difficult as well. It was virtually impossible to get a prisoner held under state laws into federal court for a hearing, as federal judges did not have the power to issue writs of habeas corpus to state prisoners. So the best Winthrop could do at that moment was propose a set of resolutions denouncing the laws as unconstitutional, which is what they did. Now, if the majority report was talking about ideals but not finding a way forward in policy, a minority report authored by Kenneth Rayner, a Whig representative from North Carolina, was far less idealistic and in fact far more faithful to contemporary constitutional interpretation. Rayner's report argued that the original South Carolina law passed in the aftermath of a threatened slave conspiracy was a means of safety, of protection, of self-defense, this is a quote, forced on the state by stern necessity. Other states had followed suit, he insisted, out of concern for self-preservation, a concern brought on by the rising anti-slavery movement. White Southerners feared that black sailors from the North would circulate abolitionist literature, and they could just not afford, for the sake of peace, to allow that to happen. So once again, going back to the language of survival of police powers. Rayner also rejected the argument about citizenship, and I won't go into details about that, but he argued that the Comity Clause, the Privileges and Immunities Clause, which I showed you before, was inapplicable in this case because just because you're recognized as a citizen in your home state doesn't mean that we have to recognize you as a citizen in our state. And when you're in a new place, you have to abide by the rules in our state. And so there was no applicability of the Comity Clause of the Constitution. He even turned it around and argued that if the Northerners really wanted it that way, they would have to go back to allowing Southern whites to allow to enforce their citizenship rights to maintain their slaves when they traveled in northern states. So he kind of said, oh, you really want to have it that way? Then we can go to Congress and get Congress to force you to allow us to keep our slaves when we're in Massachusetts or Pennsylvania. Okay, so there was a majority report, a minority report. Now, the fact that any of this reporting existed at all was the result of Winthrop's canny strategy of sending the original petitions to the Commerce Committee. And after some debate, the House agreed to print 5,000 copies of the majority and minority reports and the accompanied documentation for circulation among the American people. So it results in 5,000 copies of a document which is numbered House of Representatives document number 80 of this Congress that John Quincy Adams recorded in his diary, mailing it out to constituents shortly thereafter. So it was a way of publicizing the issue, for better or for worse. Winthrop later called for a vote on the resolutions to condemn, that he had proposed to condemn these acts, even if they couldn't do anything about it, and that proposal was tabled. So, which is what they would have expected. Of course it was tabled. Every proposal like that was tabled in this Congress. No matter, though, the printed copies of the report were soon available. The issue would stick with Winthrop, who remained a conservative Whig but a stalwart on the rights of free black sailors. By 1850, he was in the Senate, and in the course of the debate over what became the extremely punitive Fugitive Slave Act of 1850, Winthrop repeatedly returned to the issue, insisting that if Congress were going to make it easier for Southern white citizens to exercise their supposed rights to reclaim their slaves who had escaped into free states, then Congress should also take steps to protect the citizenship rights of free black Northerners who, by virtue of their profession, traveled into Southern states. So he did not let this issue go. So my argument is that the roiling debate about the rights of free black sailors in Southern ports, brought about by the testimony of people like Joseph Thompson, and then elevated into political life in states, in communities, and then in states like Massachusetts primarily, but in other states as well, and eventually into the United States Congress, this issue taught anti-slavery Northerners an important lesson, that the rights of free black people, and indeed of all free people, could not be adequately protected under the existing constitutional order. They were thinking about changing the Constitution. In 1839, John Quincy Adams proposed a gradual emancipation law in Congress, a gradual emancipation, amendment to the Constitution in Congress. Some of these people petitioned for the repeal of the Three-Fifths Compromise. So these folks already had in mind that certain aspects of the Constitution were going to need to change. But at this point, they were at a stalemate, right? There was no possibility of changing the Constitution under the regime that they had. And so the kind of existing order was going to continue. And I'll just sort of say briefly, Justice Taney in the Dred Scott decision of 1857 mentions this. He affirms that states can use their police powers even to the point of discriminating against people merely because they are of African descent. And he says, look, if anyone wants to change this, they know what to do, change the Constitution. So that's actually in the Dred Scott decision. Now, when he wrote that, Taney well knew that it would be impossible to pass a constitutional amendment at that point in 1857. Little did he or anyone else know that an opportunity, however, would soon be at hand. The chance to change the Constitution and to make progress toward a national promise to protect the basic rights of all free people arrived only because of the extraordinary conditions that brought about by the American Civil War. The 14th Amendment, which remains the Constitution's most important statement about citizenship and equal rights, established crucial limits on the police powers of the states. And in some ways, it was designed to resolve the problems identified in the struggle over the rights of Northern black sailors. The 1842 petitions from sailors and captains in the legislative archives are not filed with the tabled petitions and other petitions denied under various gag rules because of Robert Winthrop's strategy of putting the matter before the Commerce Committee. There exists in the serial set, House Report 80, that provides context for that petition, for those petitions. But that's not all. The research in this paper was also conducted in the Massachusetts State Archives and the Massachusetts Historical Society, which is where I found letters from between Bowditch and Winthrop, and also documentations of the actions of activists and of the state legislature. So one of the most exciting things about this project for me has been putting these archives into conversation with one another. The whole story of history is never really available to us as researchers. There are many gaps in the story I've told today, some of which probably can be filled with by further research, and others which may be permanent and unresolvable. But the intricate story of the movement for racial equality, sanctioned by the Constitution, moving from the very local to the state level and from the state to the federal level, could only be told through research across multiple archives. Meanwhile, I hope this work adds something to our understanding of the tortured history of race, police powers, and individual liberty in the United States. Thank you.
Thank you very much, Kate, for the speech today. Is this on? I think this is on. I'd like to go back to the beginning of your presentation, and you talked about the sailor in New Orleans. Can you, two-part question, can you talk a little bit about French law and the impact or influence of French law as it relates to slavery? And also you mentioned that the sailor had friends, because he spoke French, who came to rescue him. Can you talk about being rescued at that time? Is this a bribe? How would, if he's in jail and somebody has, it's my word against yours, what influence would be required to be released from prison?
Okay, thanks for those questions. I can't really say anything about French law, and at this point, Americans control New Orleans at this point. I mean, so the laws in New Orleans and Louisiana, as I understand it, when it comes to this issue, and the issue here, because in fact, New Orleans at that time did not yet have a Negro Seaman Act. They passed one later. This incident that he's describing is 1829. But just because they didn't have a law that explicitly restricted the liberty of black sailors in particular, didn't mean that these issues didn't come up, because the laws which were across the southern states, including in Louisiana, which had a French heritage, basically said that if you were a person of African descent, sort of at large on the streets or whatever, and you were asked to produce evidence of what you were doing, whether it was a pass from your owner if you were a slave, or some kind of evidence that you were a free person, if you couldn't produce that, you were going to be thrown in jail until either your owner came and picked you up, or you could actually produce evidence to the satisfaction of the authorities that you were a free person. So what would have happened in this situation, Thompson spoke French, some French, and he was able to use French to talk to the jail guard. He didn't say that the two friends who came and helped him were of French origin. I think they were probably Anglo. So he used French to tell the jail guard, I've got a couple of friends in this city, please go find them. What would have happened is those people would have come and, to the satisfaction of the jailers, testified that Thompson was a free man. Now, this left room for all kinds of arbitrary distinctions. I mean, it was up to the register, the clerk at the jail to kind of decide who was credible in the absence of papers. But if two elite, respected white members of the New Orleans community came in and said, hey, I've known this guy for a long time, then he could get out. So I wouldn't say there's necessarily any kind of bribe. It's about who can come in and adequately prove that the person is a free person and therefore shouldn't be in jail.
Hi, Professor. Thank you for this presentation. It was quite enlightening. My question concerns the free black sailors themselves, and your discussion sort of veers off from the petitions to talk about congressional and state legislature action. But I'm wondering what the sailors themselves are doing simultaneously beyond maybe signing the petition, or is their signature on these petitions sort of the end-all be-all of their sort of activism, or is that one of the sort of unknown elements of history that you spoke about at the end that we don't really know? We know much more about what Congress is doing on the issue than perhaps the sailors themselves on the ground.
Well, there's actually a really terrific book on black sailors in this era called Black Jacks by Jeffrey Bolster, which I alluded to, and he found, and he did huge amounts of both quantitative and qualitative research, and he found that with the advance of these Southern laws, as more states passed them and kind of cracked down, there were fewer black sailors sailing in and out of Southern ports. So it actually caused people to drop out of the business because they didn't want to risk what could happen to them in these ports. And that's alluded to in the Nantucket petition, where the captains say, and they give up this really good source of livelihood. And so Bolster's book has a lot on the lives of free black sailors. And there's a lot going on with them. And there's a really interesting, so there would be sailors' homes in cities where sailors would stay when they were in port. But in New York, for instance, I guess maybe black sailors were not welcome in the traditional white sailors' homes. And so a guy named William Powell established a black sailors' home, and that I have a feeling that Powell had something to do with that petition. Powell was a outspoken abolitionist, and he had contact with all of these sailors coming in and out. This is a place where people would sleep and stay while they were in port for a while. So there's a lot going on there. A lot has been written about by Bolster, and in some ways that's not my main question here, but certainly it's not like a big mystery. I mean, that's knowable information for sure.
Hi.
Hi.
My question is, how did gender intersect this debate? And when the ideas of citizenship and how color should not affect citizenship, should gender affect citizenship?
Right.
And did women travel to the South in the same, well, not in the same numbers, obviously, but did they come across any different discrimination than black men?
Okay. This version of citizenship, which actually excludes the right to vote. There's a debate also about whether the right to vote is a prerequisite of citizenship or not. But this version of citizenship as kind of basic rights to liberty and also to kind of own and transact property is in theory not gendered, is available to all people, men and women. So in other words, to incarcerate a black woman in New Orleans simply because, or Charleston, simply because of the color of her skin would be equally as offensive to this idea of citizenship as a man. But in practice, right, because of the institution of marriage, for example, women had less or different kinds of liberty than men to move, to mobility, right? So there's a kind of, yes, this version of citizenship is supposed to be gender neutral, but then again, women's conditions of life, especially as married women, did not guarantee or promise them the same kind of mobility as were guaranteed free men. in the actual fact, so most of these sailors were men. But there is a case in Massachusetts that actually got a lot of attention from the governor and stuff of a woman who had traveled as an employee of a family from Massachusetts to, I think it was New Orleans. And so she was basically some sort of servant or employee of a Massachusetts family, went to New Orleans, and then on the way back, their boat was shipwrecked along the coast of North Carolina. And she was picked up off that shipwreck and sold into slavery in North Carolina. And so there's a back and forth about trying to find her and get her rescued from North Carolina. And that's an instance of a woman. Now, how she got to a southern state is very different from a black sailor who would be working on board a ship. But so, that suggests that it would have operated similarly, but there just weren't as many in this particular instance. But it's an interesting question. You're next.
I always have to say, I'm from the Caribbean, so
Okay.
I come to this with a little bit different look. I grew up in the Netherlands, et cetera, et cetera, et cetera. So there's a few questions that comes out of this. Over time, with the increase of the abolitionist movement, but also with England in 1833 getting rid of slavery, with getting rid of the slave trade, at least theoretically in 1808 in the United States of America, with France eventually following England to get rid of slavery also. Did this have an impact on what was going on in the South? Did this lead to a increase in at least the need on the part of the Southern states to even more carefully control these black sailors? And the great African-American historian who just died, Slavery and Freedom, what's his name? John Franklin, right? He talks about these sailors as kind of black ambassadors, right? They were connecting, in essence, the black African diaspora at that point in time, right? So another issue is how do you see these issues with the growing backlash against African Americans, the losing of their, they had started out after the revolution with getting some voting rights, right? By the time you reach in the 1820s, 1830s, this has been wiped away. Did that, in your mind, also create a growing kind of a restlessness under the blacks to fight for all of these issues? So how do you see this playing out in more in international context, impacting upon what is going on locally? Obviously, the Haitian Revolution would be a part of that too.
Yeah, thanks. Well, I mean, one thing that comes to mind is that a lot of good work has been done on black sailors in the Atlantic as kind of agents of revolution and freedom, right? And that their ability to travel from place to place and talk about ideas of freedom coming out of, let's say, the Haitian Revolution, right? That they could spread the contagion of liberty and talk about these things. And then, really concretely, David Walker's appeal, he had, explicitly tried to get black sailors to circulate that in the slaveholding states. And so there's absolutely no doubt about that. And one thing that's kind of paradoxical, right, in a way, is that so these white Southern plantation holding interests were famous as advocates of free trade, right? They hated the tariff. They wanted as much free circulation of goods as possible. They wanted to ship their stuff cheaply. They wanted to import stuff cheaply. But they had to stop the circulation of ideas. They feared desperately the circulation of liberatory ideas, whether they were coming from other places in the Caribbean or whether they were coming from the US North. And so it's really tough to be in that situation, right? Because how do you kind of promote commerce, which they very much wanted, but stop certain kinds of people from certain kinds of ideas from coming in? So it really kind of speaks to one of the problems and paradoxes of the antebellum South.
One other question, just because I think it's important, because you're touching on something crucial. The tying of black freedom to commerce, right?
Mm-hmm.
What happens when blacks become irrelevant economically more, right, to the notion of freedom? Do you see that playing out over time? Do you see that, in essence, weakening, therefore, the ability of blacks to emancipate themselves over time?
Right, it's a huge question that we're facing to this day, right? I mean, so, you know, the question of the relationship between sort of individual freedom and liberty and the kind of development of capitalism and commerce, it's a very tricky one. I mean, I find it really interesting that this stuff ends up going through the Commerce Committee, and in some ways the parallels, right? Or, for example, the passage of federal civil rights legislation in the 20th century under the Commerce Clause of the Constitution, right? Not under the privileges and immunities of the 14th Amendment / the Comity Clause. And the Comity Clause itself, the Privileges and Immunities Clause itself that I talked about today, is similar to the commerce powers, or invokes a similar idea as the commerce powers of the Congress, in that it's about dealing with relationships among states. And so I keep coming back to this idea about, in the federalist structure of the United States, what perpetually brings people to a crisis over individual rights is the issue of crossing state lines, right? And so whether it's these guys or the Freedom Riders, it is those kind of issues that forces people to kind of look at how much of this, the kind of inequality that we permit in local areas are we going to kind of allow when the nation as a whole looks at it. So, you know, there are really interesting resonances or sort of questions about, I guess what I just said relates the kind of particular structures of the Constitution and federalism to these issues, but it always is invoking commerce. So, yeah, there's more to
And
say.
I will have to invoke the clock because we are right at the 1 o'clock time. Thank you so much, Kate, for this
Sure, thank
really
you.
informative